Hello everyone, welcome to Legal Darshan. In today's video, we are going to discuss two judgments from the list of AOR leading cases. One is the case number 8, which is titled as SRBommai and others versus Union of India and others. And the next one is the case listed at number 22, which is Rameshwar Prasad and others versus Union of India. Now, both these two cases are relating to the same provision. They are relating to the President rule, which is mentioned in Article 356 of the Constitution of India. So, before we go into these two judgments, we will first look at what Article 356 is telling us. So I will be using Indian Qanun's website and DGSCR website for having a discussion on this topic. Now, what is emergency? Basically, emergency spreads over three kinds in India. One is the national emergency, another is the state emergency, and another one is the financial emergency in India. Okay, so financial emergency has never been imposed in country till date. State emergency has been imposed hundreds of times. Many times it has been imposed, and this case is also a case of state emergency. And at that time, specifically in 1994, when this case is being adjudicated, at that time, the hung assemblies were in so much of trend. They were so much returning that this case gained importance at that period of time. Then another one is national emergency. Now you need to tell me how many times has the national emergency being imposed in our country? It's a fixed number and it's a single digit number. Okay, so please comment in the comment box below when if you know how many times the national emergency has been imposed in the country. So Article 352 tells us about national emergency. 356 is telling us about your state emergency, which we also call the president rule. And Article 360 is talking of financial emergency. Now, when I come to 356, because 356 is in the consideration today, so 356 says that provision in case of failure of constitutional machinery in the state. Now, what does the failure of constitutional machinery means? It has not been defined anywhere in the Constitution of India. One interpretation of it can be borrowed from Article 365, which says that where any state has failed to comply with or to give effect to any direction given in the exercise of executive power of the union under any of the provision of this constitution, it shall be lawful for the president to hold that a situation has arisen in which the government of the state cannot be carried out in accordance with the provision of this constitution. So basically, this case can be one that situation has such arise that there is a breakdown of constitutional machinery. This could be fit back in 356 as one of the implication. But however, what exactly is breakdown of constitutional machinery or failure of constitutional machinery, that has not been explicitly defined in the constitutional text. Now, when we come to clause 1, and that has been understood, the failure of constitutional machinery has been understood through various judicial pronouncements, which two of which we are going to discuss today. Now, when I read 356 clause 1, it goes like, if the president, the one thing, if the president, second thing, on receipt of report from the governor of the state or otherwise, is satisfied that a situation has arisen in which the government of state cannot be carried in accordance with the provision of the constitution, the president may by proclamation assume to himself, may proclaim that all or any of the functions of the government of the state or any of the power exercisable by the governor or any body or authority in the state other than the legislature of the state. Okay, so here what is president doing? President is taking all the powers of state, investing them in the executive, in himself, or also by the governor. Okay, now it can also declare the powers of the legislature of the state can be exercised only by the authority of parliament. Okay, so one president may take all the powers of the executive by the governor which are there in the state and assume them to himself. And second is that if there are any powers in the legislature, it can assume it to be exercised by the authority of parliament. Make such incidental and consequential provision as appear to the president to be necessary or desirable for giving effect to the object of the proclamation, including provisions for suspending in whole or in part the operation of any provision of this constitution relating to any body or authority in the state. Okay. Now what, and proviso is saying that you will not affect the operation of high court. So what happens when a president rule is imposed, when emergency is imposed? Basically the state government stands suspended, the state legislative assembly stands suspended, and whole of the control comes in the hand of the center, comes in the hand of the parliament or president, as the president may proclaim. So the state government, state legislature gets suspended. It does not have any kind of powers vested in them during the period of emergency. Now, this emergency can be proclaimed for once for 6 months and can extend to time by time for maximum of 3 years. Now, one thing that proviso is saying that you cannot strip off the power of high courts, and it will not affect the power of high courts in the exercise of the powers under 356. This is basically the provision on emergency which we are concerned with. Okay. Clause 3 also here is significant because clause 3 is telling you every proclamation under this article shall be laid before each house of parliament and shall, except where it is a proclamation revoking a previous proclamation, cease to operate at the expiration of 2 months unless before the expiration of that period it has been approved by the resolution of both houses of parliament. So basically any proclamation shall first be put before the parliament and that should be acted upon when it is consented to by the parliament, right? Now approved by the parliamentary resolution. That is one thing we need to keep in mind because we will be getting back to it when we will be doing SRBommai. Now, what is happening in SRBommai is SRBommai is a case belonging to Janata Dal, where Janata Dal is in power, and because of the defection, it loses majority. Now, basically, SRBommai comes in 1994 because the court is not just adjudicating the SRBommai's governmental dismissal, but it is also adjudicating the dismissal by government on the ground of 356 by arbitrarily exercising of the governor. Now, what is happening when the constitution was being drafted? In the drafting committee, Dr. B.R. Ambedkar has specifically referred that this provision is a dead lettered law because it is giving power to executive, it is giving power to governor, giving power to president to neutralize the government in any state and give the powers in the hand of the center. So this provision should always be applied sparingly. That is what Dr. Bhimrao Ambedkar has always said. Now, in these cases, what the contention has been observed in SRBommai and in other related cases which happened in Madhya Pradesh, Rajasthan at that time, what was happening was that governors were giving recommendation. Okay, so we read in 356, governors were giving reports that there is a breakdown of constitutional machinery in the state on various grounds, and therefore president was proclaiming emergencies in the state. So basically what is happening in SRBommai was in the government, and now what happened here, that some of his MLAs defected the party. They started changing the parties, and what happens here is the governor writes a report to president and the emergency is proclaimed. Now, SRBommai herein is challenging that he has the majority. He has satisfied the majority. There is a paper, there is a report which is telling that majority of the MLAs, they are quite fine if SRBommai stays in power, but the governor discards his document, discards the evidence he is providing. And ultimately, SRBommai in this case is being denied any chance of floor test. Now, floor test is basically there is a meeting in legislative assembly and the majority is decided by the MLAs in the in the legislative assembly only. Now, what is happening in this case? He was denied the opportunity of the floor test, and he therefore goes and approached the High Court of the state of Karnataka, in which the High Court also supported the view taken by the governor that since there has been a defection happening and you cannot complete the majority which is necessary for you to form the government shall be suspended. Okay. Now, in this case, when this case goes before the Supreme Court of India, what is happening here? Number one thing that the court is saying that opportunity of floor test cannot be denied. Number first thing that SRBommai is giving, that the judgment is emphasizing that the proper forum to test the majority of a government is the floor of legislative assembly and not the office of governor. So governor may have a subjective dissatisfaction that this government has not attained majority, but then that is not required. So floor test is one condition that will determine in the legislative assembly that whether the government is holding a majority or not. It does not depend on subjective satisfaction or any reports of the governor, because they will ultimately be mere allegations, right? Then the court herein is also saying that Article 356 cannot be used just casually, or it's an extraordinary power and it should be used sparingly and only when there is a genuine breakdown of the constitutional machinery and not on the malafide grounds. So routine or politically motivated dismissals were held to be unconstitutional in the light of 356, Article 356 of Constitution of India. Another thing that the court is looking at, that when a president is issuing proclamation, it also needs to apply the mind. It also needs to, keep it the decision making whether there is a condition arising and whether the houses of the parliament are approving such proclamation or not. It cannot be applied without proclamation, right? So court herein is looking at federalism, the feature of federalism in this case. Court is basically saying that you cannot compromise the spirit of federalism in the Indian constitution, because the constitution of India itself is guaranteeing you the federalism, right? So federalism has been incorporated as the basic structure doctrine in the Constitution of India, and you cannot discard that. So there is a center-state relations which was upheld, which was discussed in the Sarkaria Commission report, and the court's judgment in the case of SRBommai as well as the Rameshwar Prasad, which we are going to discuss next, is aligning with what the Sarkaria Commission has said, that state and center are working in a cooperative federalism. They are working for the rights of the people. They are working for the public welfare. So if these kind of provisions are applied merely on political motivations by the governor, when he declares that there is a breakdown of constitutional machinery in the state without giving the opportunity of a floor test, such kind of acts cannot be deemed fit in the light of Article 356 of the Constitution of India. So the court here is noting that even though we are quasi-federal in nature, even though Article 356 does exhibit significantly that there is a unitary bias in the Indian Constitution, we cannot declare or we cannot disrespect the autonomy of the state. The misuse of Article 356 disrupts the federal balance in the country, and such misuse shall always be subject to judicial review. Now the courts are here declaring one more thing, that any proclamation under Article 356 shall also be subject to the judicial review by the courts, right? So it will come in the scrutiny of judicial review as well. Now here, one thing that floor test has to be done to prove majority in the legislative assembly. Just because a governor is having subjective satisfaction, that is not enough. Third thing is that the powers under Article 356 must be used sparingly and not for any kind of political motivations. There should not be any arbitrary use of Article 356, and state governments should not therefore be dismissed on the politically motivated grounds only. So basic structure doctrine, floor test was upheld. Basic structure doctrine, which is saying, which is upholding federalism, which is upholding judicial review, is again upheld in the case of SRBommai, as well as the court is also upholding the validity of the floor test. Now, One thing that the court here is also saying about secularism, that once any state government, if any state government is acting contrary to the principle of secularism, if any state government is, going against the principle of secularism, that can constitute a valid ground under Article 356 for declaring breakdown of constitutional machinery. Now, why this is happening? Because a lot of governments at that time were uh, being declared hung, or being imposed upon the president's rule under Article 356, because at that time in 89, 1991, a lot of riots were going on. Okay, so court is also saying that if government is involved, if government is not able to control, and it is basically acting against the principle of secularism, then also it will be a valid breakdown of constitutional machinery. The violation of principle of secularism forms a valid ground for breakdown of constitutional machinery, and the state assembly may be dissolved on such ground, and Article 356 presidential rule can be imposed in such a case. So this case is relevant because it is now talking of few things. I will list them: talking of secularism, federalism, and judicial review, and therefore upholding back the spirit of basic structure doctrine, in which was upheld in the case of Keshwanand Bharati. Then it is talking of the floor test also. And then it is saying that there shall not be arbitrary use of the power vested in the governor by virtue of Article 356 of the Constitution of India. Now, a similar kind of observation is again made in the case of Rameshwar Prasad. The court is also looking at what Rameshwar Prasad judgment is doing. And in this case, what is happening? We will look at that. So basically, what is happening in Rameshwar Prasad is that Bihar assembly elections led to a hung house, because no party could attain majority in the Bihar assembly elections that were held in the year of 2005. Okay, so now what is happening, that the parties wanted to meet for having a government, coalition government, but the governor recommended that there should be dissolution of the assembly without allowing the house to meet even for a single time. Okay, so there were chances that majority could be declared by way of the floor test, power could vest in one party, coalition might happen, but governor recommended that it should be dissolved. It should be dissolved. The assembly should be dissolved, and therefore he writes a report to the president of India, and therefore a proclamation is made in this case as well. Okay, now the reason that was given for the proclamation was that unethical means were being used to form the government. So basically, the governor asserted that there was horse trading happening. There was planning of doing defection to cobble up for the government. Now, this did not have any proof. This was merely an anticipation of the governor, on which he is writing a report to the president of India, and therefore the assembly was being dissolved. So the case is holding up that, again, floor test's validity is upheld in this case. It is said that only the floor of the house is the constitutional forum to determine the majority. As governor, you cannot have your subjective satisfaction overrule the democratic process, the floor test which happens in the house. Okay, so floor test is the only procedure which will be used to prove majority in the legislative assembly. It can be conducted by the speaker, or as directed by the governor, or the way the court directs it, because it is basically, we are also looking at separation of powers, right? So if a party has to hold a majority, if the coalition has to happen, it is the legislative freedom, it is the freedom of the members who are forming the part of legislative assembly, and the governor is merely executive in nature. So he should not have a subjective satisfaction whether the government will be formed finally, or whether the any party will have majority, because coalition might happen, parties do have a chance to come together, right? So legislative confidence has to be ensured, so that governmental legitimacy is always there. Now the court herein is also saying this proclamation under 356 is not satisfying the failure of administrative machinery, because what is happening, you are not even allowing to convene a meeting before even the MLAs, the elected MLAs met. The proclamation was made, the report was given by the governor to the president. Okay, now breakdown of constitutional machinery may arise. Number one, we discussed it in SRBommai, when there is, religious structures, secularism structures violation, when there are riots, when the government is unable to control what is happening, that may happen. But and it can also arise when no party can form a stable government, constitutional provisions are subverted, and most importantly, democracy is under threat. Okay, any political instability or loss of majority, unless tested on the floor, shall not be included in the case of breakdown of constitutional machinery, right? So the two cases are holding up these things for us. Rameshwar Prasad case is supplementing to what SRBommai has done in the Indian constitutional scheme, and it is also holding that Article 356 should not be used casually. It should be used with restraint, sparingly. Judicial review is upheld, that even on the presidential satisfaction, even on the proclamation by president, judicial review shall be available. Majority will always be tested on the floor. Political motives, politically motivated reports of the governor or subjective satisfaction of the governor is not enough to justify constitutional subversion. And governors and the union, they must also act as neutral constitutional authorities and not as the political agents. Now the two cases are very, very important to uphold the democratic procedures, the spirit of federalism, and the electoral mandates that must be respected by all the governors or by all the party who are ruling, or all the governors or all the people who are holding the constitutional offices, right? So these two cases were the part of the discussion. This was, again, I will reiterate, this was case number 8 and case number 22, both relating to Article 356 of the Constitution of India. We will stop here today. I hope this discussion was useful to you. Thank you everyone for watching. Please stay tuned, keep watching, keep sharing, keep liking Legal Darshan. Thank you everyone. Have a nice day.